All right, we're going to work our way through these trial transcripts. We're on day 13. There's 23 days total, I believe. This one is called Transcript Trial Testimony Sutherland. It's 75 pages long. Anchorage, Alaska, Tuesday, May the 29th, the year 2012. Trial by jury, day 13. All right. Let's try to maybe knock out 25 pages. I got a little break here. All right. Miss Lamoureux, the government calls Agent Sutherland. All right. Plaintiff's witness sworn. Direct examination. Yes, sir, I do. Miss Lamoureux, good afternoon. Hello. Could you please tell us your full name and spell your last name? My name is Richard Sutherland. Sutherland. Where do you work? I work for the Federal Bureau of Investigations. I'm assigned to the Fairbanks FBI office. And you're a special agent? Yes, ma'am, I am. I'm very special. How long have you been a special agent with the FBI? 3 years. And prior to that, what did you do? I started my law enforcement career as a public safety law enforcement officer in South Carolina, where I completed my Bachelor of Science degree in criminal justice. After I graduated, I worked for the next 13 years for a sheriff's office in North Carolina as a deputy sheriff and eventually being promoted up to the undersheriff of that department, working in corrections investigations, technology, special investigations, and eventually management. So how many years have you worked in law enforcement? 19 years. Can you explain how this investigation started? The Anchorage Division of the FBI began an investigation of Schaefer Cox in early 2010 after receiving information from several Montana offices of the FBI about allegations that had been made against Mr. Cox by individuals who had become aware of some of the speeches that he was making in Montana. And you indicated that was in early 2010? I believe that the Anchorage Division opened their investigation of Mr. Cox in February of 2010. And was there anything that happened shortly after that that was of interest to the investigation? There were a lot of things that began to happen that were of interest to the investigation as far as intelligence and information. Locally, we became aware that Mr. Cox was arrested twice. He was arrested twice by the local law enforcement shortly after we had opened our case. And I guess we should provide some background here. Can you tell the jury what happens when the FBI, what happens within the FBI when you open an investigation versus when it becomes a full-blown investigation? We have several levels of investigations or assessments that we conduct when allegations are made to us. And there have to be certain thresholds met as far as corroborating allegations before we can investigate somebody for some alleged conduct. So we opened up a preliminary investigation on Mr. Cox in February of 2010 based on information that was referred to us, and then our investigation began to see whether or not we could corroborate those initial allegations and whether that would lead to a full investigation, which would allow us to use additional investigative techniques that our preliminary investigation did not. Can you tell the jury what some of that early information that you received was, what those early allegations were, and what that information was? We were supplied information through law enforcement channels that Mr. Cox had traveled to Montana and that he had made speeches. And in his speeches, he had claimed to have 3,500 individuals in a militia under his command, and that they were armed with weapons, which, if true, would be illegal to possess and use. And also the allegations were that he was advocating overthrow or armed resistance to the government in certain circumstances. So it wasn't just because there was a militia. That's not the allegations that were made, no ma'am. It was in reference to potential violence, weapons, and resistance or overthrow of the government, is my recollection. And this was coming from more than one source? Yes, ma'am, it was. When did it become a full investigation? I believe the Anchorage Division converted this to a full investigation, either in July or August of 2010, roughly 5 to 6 months after the preliminary investigation was opened. And what are some of the reasons of what prompted that? The case agent is responsible both for investigating the case and reporting the status of the case to FBI management. And as part of that reporting, they have to report out if there are certain pieces of information that had been collected within the investigation that corroborate allegations, or if new allegations are uncovered that would require the FBI, as part of our mandate, to investigate those. So based on the information that was reported to management by the case agent, it was recommended that this investigation be converted to a full FBI investigation, and that Mr. Cox continue to be investigated, and that all allowable investigative techniques under our internal controls be used. You referred to a case agent. Who is the case agent on this investigation? I am. And what is the case agent's role? You described that there's some communication within the FBI. What does the case agent do? Just as in traditional law enforcement, the case agent is the detective, the investigators who's tasked with working a particular investigation. And depending on the size and scope of the investigation, they also can become somewhat of a manager when significant resources are allocated to the case. So they investigate, they make sure appropriate techniques are being used correctly, they document, they report information, they coordinate within the FBI, and they coordinate with their law enforcement partners who may be assisting in the investigation. What was done with the information that you received in the summer of 2010 that resulted in this becoming a full investigation? I recall information that corroborated the extent that Mr. Cox was commanding a militia, but there was no specific information about illegal weapons. There was information that began to come in about violations of weapons laws, a trip that he made to Fort Wainwright in which he was alleged to have been armed and had interaction with the Fort Wainwright Police Department and the Public Safety Department. The fact that Mr. Cox was arrested for violating state law was factored in, and information about him allegedly surveilling or arriving at the home of a trooper and having interaction with Lieutenant Wall. Those are some of the specific factors that I recall that led to the conversion to a full investigation. And what about any information related to his OCS case? Were you aware of any information at that time? In May and June, we became aware through our liaison that the Alaska State Troopers, that Mr. Cox was involved in a state matter in which OCS wanted to interview his child, and that he either disagreed or was not complying with their request for an interview. And that subsequent to that, there was law enforcement reporting that there were armed individuals who were guarding or standing perimeter around his property, and that there had been resistance to the attempts to interview the child, and that Mr. Cox essentially trying to keep the state troopers from becoming involved in serving a writ if the court ordered one. You referred to a visit that he made, that Schaefer Cox made to Fort Wainwright. What did you learn about that visit? And I guess we should back up and explain, you're working with other law enforcement agencies. You're receiving information from other law enforcement agencies? Throughout this investigation, the FBI was conducting criminal investigation for allegations of violation of federal law. And at the same time, we were collecting information and sharing it with law enforcement partners, as we were both a national security agency. We have investigative resources, and we're an intelligence gathering and sharing agency. So under the umbrella of our multiple mandates from Congress, we were collecting information and sharing it out with local, state, and federal partners as we felt it was appropriate, while we continued to conduct our criminal investigation. And similarly, did you receive information from those other agencies Oh, yes, we did. And what did you learn about Schaefer Cox's visit to Fort Wainwright? My understanding was that Mr. Cox and several other individuals had visited Fort Wainwright, seeking or looking for the Provost Marshal, which is essentially now a more civilianized, non-traditional role, and that Fort Wainwright Police Department handles law enforcement services. They do incorporate traditional military policemen in their law enforcement response, and that they fall under a general public services or public safety department at Fort Wainwright. And Mr. Cox had visited those facilities, seeking to speak to individuals who were in the command structure of the Provost Marshal or Law Enforcement Police Department, and serve a writ upon them, compelling them to provide protection for him and his family against federal agents, and seeking to gain what he coined as some type of asylum on the base from the Department of Defense. Do you know if the military grants asylum? The Department of Defense operating domestically does not offer asylum from federal investigation, federal investigative agencies, or any type of asylum that I am aware of. Why did the military share this information with you? The police chief of Fort Wainwright asked to meet with the state troopers and the FBI to relay the information because of Mr. Cox's visit, his attempts to gain asylum, his attempt to serve a writ, and because the content of some of the comments that were made at his police department concerned him, and he thought they should be reported out and shared. Can you go ahead and tell us about what Schaefer Cox said? My understanding of the information was that Mr. Cox made a comment that was in the context of possible or potential bloodshed. I don't know in regards as to what specific activities, but that was what was shared with us. And what sort of time frame are we talking about here? June of 2010. And was there suspicion that Mr. Cox could have been armed at that occasion? His actions that were described by the law enforcement officers were observed, who observed him there, where it appeared that he had some type of pack, a fanny pack, around his waist. He appeared to be wearing body armor. He appeared to position himself in the visitor area or hallway reception area of the police department so as to keep his back against the wall. And based on their observations, they considered that he was potentially armed at their facility. And do you know if he was by himself when he went there? He was not. He was with at least 2 other people. Do you know who those other people are? I don't know for sure. Were you aware whether at that time Mr. Cox had any restrictions regarding carrying firearms? And what was that? Oh, wait a minute. Were you aware at that time Mr. Cox had any restrictions regarding carrying firearms? Yes, ma'am, I am aware. And what was that? My understanding was that as part of his condition of release on a pending state case, he was not allowed to possess a firearm off his own personal residence. What did you do with the information you had received? From Fort Wainwright? Affirmative. We documented that information and included it as part of our investigation and considered it as we moved forward. Is that one thing when you have an investigation like this, you're gathering information? Oh, yes, ma'am. Do you, as human sources, work with people to help you gather that information? The utilization of human sources is one of the investigative techniques that is followed by the FBI in certain investigations. Can you explain that? Certain investigations. Which ones? There are. We have too many rules and internal controls for me to describe at length. But in a criminal investigation, with the majority of the subject matters that we investigate, if we have a preliminary or a full investigation, then we are allowed to utilize a confidential human sources or human sources as one of our investigative techniques. And so the FBI refers to these people as human sources, but do other people call them informants? Yes, ma'am. And does the FBI sometimes task human sources to record their conversations? We do. And what types of conversations are those? Specific to this case or in general? Specific to this case. In this case, because we are using a specific human source who was considered to be a high-risk source when he came to us. Actually, let me back up. I want to explain first how these conversations, when the FBI uses confidential human sources to record conversations, do these human sources consent to have their conversations recorded? Sure. Foundationally, if we speak to someone who agrees to become a confidential human source for the FBI, we must get them to volunteer to work with us. Of course, I'm not going to tell you anything about the $77,000 we paid him and the fact that he hoped to earn another $300,000, plus they paid all my living expenses, to J.R. Olson and to Bill Fulton. Anyway, they must agree to volunteer to work for us. Well, being a narc snitch for the government sure does pay well nowadays. My goodness. Right, let me read that again. We must get them to volunteer to work for us. Volunteer my foot. You're paying them tens of thousands, if not hundreds of thousands of dollars. And then if we intend to use as an investigative technique consensual monitoring or asking them to record certain conversations, we let them know that this is a potential technique that we are contemplating for using with them, and we ask them if they will consent to have certain of their conversations audio or video recorded. And then we have to specifically identify to them the people that they might record. So my understanding is there's a number of investigative methods that the FBI uses in its investigations. That's correct. And these consensually recorded conversations is one investigative method. That is one technique that we utilize when appropriate and allowable. And there's a range of other techniques that the FBI sometimes employs in its investigations. Yes, ma'am. So people hear about tapping phones or wiretaps, things along those lines. Those are tools that are available to the FBI in certain scenarios. Yes, ma'am, they are. And are those any of the techniques that were employed in this investigation? In this investigation, all of the recording that was done through consensual monitoring, where a human source was tasked to record, knew they were recording, and then did record voluntarily. And can you explain what sort of protocols or internal rules the FBI has even with regard to those consensual recordings? We're required, if we're going to use consensual monitoring as an investigative technique, that we have an investigation open that allows for the use of that technique, and then we have to identify specific individuals who we are going to record and how it will support the investigation. We have to annotate that the human source has agreed to allow their conversations to be recorded, and then we submit that documentation to management for approval of the technique. Management would be Loretta Lynch, by the way. How do those protocols compare or relate to what's being allowed under law? They are more restrictive than what is allowed under federal law. When this investigation began, how many subjects were there? How many people were the subject of the investigation? Just one. Schaefer Cox. And then did that change over time? It did. Can you explain how the internal protocols you were just talking about relate to that change in the investigation? Specifically as to the technique of recording or consensual monitoring along the timeline of the chronology of this investigation. There were certain occasions where the source, Mr. Olson, met with individuals and he was not allowed to record them because of internal FBI controls. If Mr. Cox was going to be present at a conversation, he was allowed to record. If he was meeting with someone who had not authorized him to record because of our own internal controls, he was not authorized to record. And then as the investigation proceeded, Then he was tasked to record other individuals. As the investigation proceeded, there were other individuals who became the subject of related but separate investigations. And as the investigation were opened and authorized on those individuals, they went through the same steps for seeking compliance with internal controls. And as those individuals met the internal controls, then the source was allowed to start recording additional persons. And in all of those situations, the sources consented to record those conversations. Yes, ma'am. We've been talking a little bit about human sources. Can you explain what the process is within the FBI to open somebody up as a human source? We have both proactive and reactive measures for acquiring human sources. Sometimes we specifically go out and seek people who have access to certain information and see if they are willing to work with the FBI as a confidential human source. In other situations, through our own investigations or through the partnership with law enforcement, we came into contact with individuals who are seeking to provide information, and we began a relationship with that individual as a human source for the FBI. And assuming you're going to begin that relationship, what steps do you need to take as the case agent or the FBI agent who's going to be handling the human source? Once we identify an individual and speak to them, and they agree to begin reporting as a human source, we have a lengthy conversation explaining how they might be utilized, what the procedures are, what the relationship would be, what the rules will be. Make sure that they are doing it. Make sure what they're doing is voluntary. We have an extensive debrief of the individual to see what it is either they are willing to provide, what they think they can provide, or if it is something that we think they can provide because they have access to certain information. We explain what that is. And then after all the debrief and conversation occurs, then we create some internal paperwork to officially identify them to management as a human source that we are going to begin utilizing. And then we conduct additional internal checks in compliance with our policies. Question. You indicated that there are certain rules that they agree to abide by. Can you provide the jury with some examples what those rules are? There are a list of rules that are specific to certain circumstances if access to certain information is sensitive or considered sensitive by the FBI. There are specific rules, and then there are general rules that are given to all of the human sources. And some of the more generalized rules are reminding them that their services are voluntary, reminding them that we seek to protect their identity as long as we possibly can, unless it becomes revealed through a court proceeding that we are not allowed to lie, that they're not allowed to lie to us. If they can't represent themselves as an FBI agent, they can't do anything without our tasking, and they can't represent the U.S. government. Question. And then, excuse me, counsel, it's about time we took a break. We'll take 15 minutes, folks. All rise. The matter is in recess for 15 minutes. All rise. His dishonorable, the court, the dishonorable United States District Court is again in session. Please be seated. You can bring the jury back. Miss Lamoureux, Your Honor, we're not going to finish at 3:30 today. I apologize for that estimate. I never had a lawyer give me an estimate that was accurate yet, so you're right in line with all the lawyers I've had in front of me for the last 44 years. Welcome aboard. But it's okay because my estimates are no better than anybody else's. The court. Ladies and gentlemen, one of the witnesses this morning was talking about courtrooms and the bar, as we have a rail here. Almost all American courtrooms have a rail that separates the galley or the public seating from the well or the pit. And that's why they say when lawyers are admitted to practice that they pass the bar, because they're allowed to come inside the well of the courtroom, the court. So that's why that's a bar, or that's why we refer to the bar and passing the bar. A little history. We'll continue, Mr. Sutherland, Agent Sutherland. Miss Lamoureux, before the break, you were describing a little bit of some of the rules that the human sources agree to abide by when they're going to work with the FBI. Does the FBI then periodically review those rules with the human sources? We are required to at least yearly provide those rules, or we call them admonishments to human sources, and review the investigations that we're working on to see if any of those have changed or needed to be amended. The FBI calls them admonishments. Yes, ma'am. But it's not that they're doing something wrong. That's just what the FBI calls them. It's a term that we came up with. They are essentially rules, and it's referred to as admonishing the source. And who typically does that within the FBI? Typically there is a primary handling agent or contact agent, and then there is at least one co-case agent another agent that has met with the human source face to face, that they're familiar with working with. And they know that the individual is also an FBI agent. And typically it is the primary handling agent or one of the case agent who provides those yearly reviews of the rules. And how many human sources were tasked by the FBI to consensually record conversations in this investigation? Just 2 that I am aware of. And those 2 are Bill Fulton and Mr. Olson, Gerald Olson. Remember, he said that I'm aware of, because I think Aaron Bennett is a part of that too. Question: can you explain to the jury what your understanding of Mr. Fulton's role is in this investigation? This specific investigation? Well, first, we should back up and talk about his role as a human source with the FBI. If you could provide some background to the jury, that'd be great. My understanding is that Mr. Fulton walked in as a volunteer to the Anchorage Division FBI office sometime in April or May of 2010 with information to provide to the FBI that was unrelated to Schaefer Cox. And with that information, he met with an agent and agreed to provide that information and began to work as a confidential human source with the FBI. And that at some time after the agreement he began to work, he was tasked by his primary handler or his case agent to also collect information in the Schaefer Cox investigation. And were you his handling agent? No, I never was. What's your understanding of when he was first tasked to do something in this investigation? He was invited to the grand opening of the Far North Tactical Surplus Store in Fairbanks. It would have been around June 12th, 13th, and 14th. And sometime before that, in the week before, so he was invited to attend the grand opening, and he related to the FBI that Schaefer Cox would be at the grand opening and would have a table of some sort displayed at that opening. So he was tasked to attend that as he already was a vendor. He was also tasked to attend it as a source. Question: and was he tasked to consensually record conversations during that event? No, he wasn't. He was tasked to attend it, report conversations that he had with Mr. Cox, and to provide any paperwork that he received from Mr. Cox to the FBI. And did he do that? He did attend, and he did make reporting after several meetings that he had with Mr. Cox. When was he tasked in this investigation? In August, I believe. It was August 18th of 2010. What was he tasked to do? He was tasked to contact Mr. Cox and kind of amend or repair their relationship, as they had a falling out of some degree at the June meeting, and he was tasked to make contact with Mr. Cox again to see if he could begin to open up a dialogue or communication and begin having conversations with Mr. Cox again. Is it your understanding that Mr. Fulton and Schaefer Cox had met prior to Mr. Fulton being tasked as a human source in this investigation? Yes. They had met prior to him coming to work with the FBI. Then you indicated he was tasked to try to make amends or something along those lines? Yes, ma'am. Do you know if that happened? It did. He communicated with Mr. Cox in some way and received a message back from Mr. Cox after his communication to Mr. Cox. And then when was Mr. Fulton next tasked in this investigation? I'm not aware of any specific tasking that he received until February 4th of 2011. And what was that? Mr. Fulton reported that a militia summit or a militia conference was being organized by an individual by the name of David Luntz in Anchorage, and that Mr. Cox was on the agenda as a speaker. Mr. Fulton was tasked to facilitate, help make arrangements for that conference, and to provide reporting on Mr. Cox if he attended. And did that happen? The conference occurred. And what happened? The conference occurred. Mr. Cox did not attend, but he sent in his place Lonnie Vernon and J.R. Olson, or Gerald Olson. And Mr. Fulton met with them on 2 different occasions in his room, and they also held the actual conference or the meeting in the conference room at the hotel here in Anchorage. And was that recorded, the meeting in his hotel room? Yes, ma'am. Those meetings were recorded. And did he consent to have his hotel room recorded? Mr. Fulton consented to have his motel audio and video recorded by the equipment that was placed in his room by the FBI. Do you know when he was next tasked in this investigation? Sometime February 20th or 20th, sometime around the 20th of February, he was tasked to follow up on a conversation that he had with Lonnie Vernon and J.R. Olson about some equipment that he had ordered from him. And do you know if that equipment with the defendants? I'm not aware that he specifically spoke to the defendants. I know that he spoke to Mr. Olson. What's your understanding of the last time that Mr. Fulton had any contact with any of these 3 defendants? I believe the last contact he had with any of the defendants was around February 11th or 12th. He had communication with Mr. Cox right before Mr. Cox became a fugitive from the state. And what kind of communication was that? Cellular telephone is my recollection. How many times, if you know, how many times did Mr. Fulton interact with any of these defendants during the course of the investigation? In person? In person. In person, I'm never aware of a situation where he interacted with Mr. Barney. There was a weekend that he interacted with Mr. Vernon, which would have covered portions of, I believe, 3 days, maybe 2 days. That's the February 4th, 5th, 2011 weekend you just referred to. Yes, ma'am. Okay. And then he had 3 or 4 face-to-face personal interactions with Mr. Cox that I'm aware of. And approximately when were those contacts? The majority of those interactions he had with Mr. Cox were in the summer of 2010, and I'm not aware of any. I'm not aware of any personal interaction he had after that. Now, you mentioned there were 2 human sources in this investigation, Fulton and Olson. Can you provide the jury with some background as to how Mr. Olson came to work with the FBI? We received information from the Alaska State Troopers in May of 2010 that they were operating an informant who made allegations that there was a federal official who may be involved in some type of bribery scheme involving allowing contraband into the United States from Canada in exchange for payment. And what was your relationship with Mr. Olson? At that point, I had never met him. We had no working relationship with him. We received that allegation from the Alaska State Troopers, and because it was something that we have a congressional mandate to investigate, we felt that there was enough corroboration in the allegation to look at it. So we began an investigation with the Department of Homeland Security and with Customs and Border Protection, and we agreed to sit down. I'm going to stop on page 26. All right, let's start with page 26 and see how far we can go. Okay. And we agreed to sit down and meet with Mr. Olson and hear his information or his alleged allegation firsthand, and what became of your relationship. I met him with the troopers and introducing him and meeting him with the other individuals. I was investigating the case, the allegations, and after I met him and evaluated him, I decided to ask him if he would be willing to work for the FBI. Well, that's just 2 peas in a pod, Gerald J.R. Olson in the FBI, and as a confidential human source, and that became my relationship with him. You were his handling agent? I was. You earlier indicated you used the term high risk. Was that your assessment? That was my personal assessment. That's not a particular designation that the FBI has. That's how I would have characterized him as a human source or as an informant. When I met him, I learned of his background and I learned of the circumstances that he came to work with us under. Okay, and what do you mean when you say the circumstances? I understood that he was facing potential, or that he had been charged with a felony in the state of Alaska, and that he was seeking to gain consideration or some leniency in his sentencing by providing assistance to law enforcement. And you earlier described how there are protocols when you open someone up as a human source. You have some sort of debriefing where you gather information from those individuals and learn about them. Did you do that in this case? Yes, ma'am, I did. Can you tell the jury about that? I met with Mr. Olson and other investigators and spoke to him about the allegations he was specifically making against the federal employee. And then when I decided to consider him for a role as a confidential human source, I debriefed him extensively on both his personal past and his criminal past and what had led to him walking into our door and to speak to me. So he provided the information about his past activity. Yes, ma'am, he did. You indicated that there are certain protocols that you follow when you open a human source. Did you follow those protocols in this case? Yes, ma'am. With Mr. Olson, did you take any additional steps? I did, because I considered him to be a high-risk human source based on his past, his criminal past, and what he was currently facing. I decided to take additional steps to make sure he understood the rules he would be working under and to validate going forward with the information that he was providing to me. Can you describe what some of those additional steps are and also the validation that you're talking about? Rather than just verbally making him aware of the rules, we pulled out the rules and went over them in great length and made him sign them, that he understood those rules and that he would not violate them. And when I asked him if he would be willing to record and made him understand that the only way I was going to agree to work with him as a source and receive his information is if he was willing to record so I could corroborate the information he was providing, and I could use the recordings as one of the validation tools that we use to validate our human sources. And so did he indicate that he was willing to abide by those rules? Yes, ma'am. And he was willing to record? Yes, ma'am, he did. And did he indicate that he was willing to follow those additional steps, those validation measures that you wanted to take? Validation is not something that we communicate to the source. He knew that he was going to be required to record and provide recordings to verify his information. Validation is an additional step that we take to make sure that our source is being honest with us and doing what they are supposed to be within the confines that we give them. Specifically with regard to recordings, what steps did you take, Mr. Olson, when you started working with him? When we first started working with him and he knew that he was going to be doing recording, we provided him recording devices that he could neither turn on or off. We controlled the on and off, simply deployed them with him for the purposes of him using in the investigation. And at that point, he wasn't tasked in this investigation. There was still working on that in the other investigation. This was not the investigation of Mr. Cox. It was other cases. At a certain point, did he begin to provide information on this investigation? Yes, ma'am, he did. Can you describe how that happened? During his debrief, and he had provided information about his past, the FBI used a system with our human sources that we call cross-tasking, and determine if the human source who are working on specific matters are suitable to report on other things that are within our investigative purview. So because of his past and because of the fact that sometimes in the middle of June, he told me that he was aware that Mr. Cox, I believe he said made some headlines or been in the news, and he thought the FBI might have an interest in Mr. Cox. He said that he would be willing to work on an investigation of Shepard Cox if the FBI was investigating him. Why did you think his ties to the Montana militia were relevant? Because when we talk about suitably of a confidential human source, it has to be someone that if we put them in a situation, we feel that they can function, that they can speak appropriately, act appropriately, if they're asked questions about their background or their involvement. If they are vetted in some way, that they would be able to respond correctly, and I felt that his background supported that he would be able to work an investigation of an individual who was involved with the militia and weapons. And did he indicate that he had met Shepard Cox before? He told me that he had met Shepard Cox sometime in the winter of 2009. At some time a political fundraiser or gathering, and that he had met Mr. Cox briefly face-to-face and had received a contact number for Mr. Cox, and that he would be willing to reach out and contact him in my direction. When was Mr. Olson first tasked in this investigation? I think it was the last week of June 2010. And what was that? He was tasked to call Mr. Cox and try to set up a meeting where he could meet him face-to-face and talk. Did that ever happen eventually? Tell the jury what happened. My recollection is he made 2 phone calls or left a message with Mr. Cox and did not initially receive a call back. And so then what did you do? I had him contact an individual that he told us he knew in Montana by the name of Paul Stramer and speak to Mr. Stramer about Schaefer and see if he received any direction or if Mr. Stramer offered to make some type of telephone introduction with Mr. Cox. And what's your understanding of who Mr. Stramer is? My initial understanding came from Mr. Olson, and it was that someone who was involved in the Montana militia or had been at some point, and that he was also involved in producing literature, DVDs, publications in support of the militias and patriot movement, and that he traveled to Alaska for business purposes. After each of these taskings, well, first I should ask, were you with Mr. Olson while he was making these phone calls? I believe that when he called Mr. Cox twice in June, I was with him, and that when he called Mr. Stramer, I was with him. And then at a certain point, did you task him with reaching out to Mr. Cox again after the calls with Mr. Stramer? Yes, ma'am, I did. And did that happen? It did. To tell the jury about that, he was able to talk to Mr. Cox over the phone eventually. It was either sometime toward the end of July or the beginning of August. It's my recollection, and Mr. Cox was willing to have him come to a militia conventioning and have some conversation to the effect that he would be allowed to join the militia, and told him that someone would be contacting him in regards to a militia commissioning. And did that happen? It did. And did you task him to attend the militia commissioning? Yes, ma'am, I did. Can you tell the jury about that? He was invited to attend a commissioning/barbecue at the home of Coleman Barney in North Pole, and he was given directions and a time to attend. And he was provided with a recording device and tasked to attend and to see what was going on. And if given an opportunity, to join the militia. And did that happen? Yes, ma'am, it did. Now, after he went to the commissioning ceremony, how did he relay the information to you? The standard rule for all of his taskings when he met with the subject of an investigation was that I would contact him prior to him undertaking the tasking. If I was going to have him record, I would provide him with a device and make sure he knew how to use it. He would attend the meeting or whatever function it was, and I had to task him to do. And when he had completed that, he would report to me that he was done. We would meet, and I would debrief him and find out that the information that he had learned during this tasking, and then he would provide back to me the recorder documents or other evidence that he might have obtained during his meeting. And then what would you do with that information? The information that he provided to me in the debrief, I would write up and create a report. The recordings were listened to and compared to the reporting to make sure that he was reporting accurately, and then the information was used to support the investigation, or if he was intelligent. If there was intelligence that needed to be shared out to other investigative partners, we would share that intelligence out. You indicated you listened to the recordings at some point after the debrief. Yes, ma'am. How would you characterize the accuracy of what he reported to you? I believe that I wrote up 50 to 60 contact reports over the scope of the investigation, and the information that he provided within those contact reports were extremely accurate and was corroborated by the recordings, by other law enforcement observations, by interviews, or by evidence that was collected. Now, after this militia commissioning ceremony, what was the next interaction that he had with the defendants that Mr. Olson had? He had several communications after the commissioning, and that this would have been the last week or two of August, and he was invited to attend training for the individuals who had just recently been commissioned into the militia. And did you task him to go to that training? No, I told him that he was not allowed to go. Why not? Part of the training, as represented to him, was going to be training that centered around firearms, the use of firearms, firearm familiarization. And we were not authorized to send him to that training. Sometimes there are documents, FBI documents, that refer to OIA. Can you tell the jury what that is? OIA is an abbreviation or an acronym for otherwise illegal activity. And what does it mean to you? OIA authority is a situation where we are going to task a human source to engage in activity that would be considered illegal for someone else to participate in. And so as part of our internal review, if the agent is going to suggest that the human source participate in this, they propose it by filling out forms, and then it is reviewed by the supervisor and the division legal counsel to make sure that what we're doing is appropriate and allowable both under the law and under our internal restrictions and guidelines. Did you seek any of those authorizations or approvals with regard to Mr. Olson in this investigation? Yes, ma'am, I did. Can you tell the jury about that? He was granted OIA authority in relation to handling weapons, in relation to engaging in conversations that could be considered criminal in nature, and he was authorized to have his Alaska driver's license stamped or imprinted by a machine similar to a credit card machine, which is a violation of Alaska state statute. And so you went through the internal process of getting approval for that? Yes, we did. After the militia commissioning ceremony, what was Mr. Olson next tasked to have contact, or when was he next contacted by the defendants? He was contacted several times in August related to the training, and then he was contacted very minimally in September or October, just related to general things that were going on with the militia. And then in November, he was called by Schaefer Cox and told that he needed to be available for a briefing. Mr. Cox had some information that was going to be significant, and he didn't want members of the militia to be caught unaware by it. And did you task him to go to that meeting? There were several meetings that Mr. Cox was holding, and he called Mr. Olson to inquire as to which one he could attend. And because I had to have Mr. Olson travel back to Fairbanks to do that, he ultimately was able to attend his briefing on November the 19th at Mr. Cox's house. And so you tasked him to go to that meeting. I did. What was Mr. Olson? Hold on just a second. Where we at? What was Mr. Olson tasked to do at that meeting? To listen to what Mr. Cox was going to brief him on and to record the conversation. And did he do that? He did. And did he then debrief you about that? I met with him after that, and I debriefed him and found out what had been said, what Mr. Cox's plans were, the information he was providing, and I received the recording device from Mr. Olson. What did Schaefer Cox and Mr. Olson ask of Mr. Olson at the meeting? He made him aware of several things, several what I would call operations that the militia was getting ready to hold at Mr. Cox's direction. And Mr. Cox sought from Mr. Olson his participation and willingness to participate in the operations as they were described to him, and see his role would be willing to play. And then Mr. Cox relayed to him a plan that was titled 7-Point Plan. What were those operations related to? One of them was related to a state court appearance that Mr. Cox had scheduled for November 23rd at the state courthouse, and that operation related to security for Mr. Cox going to and from the courthouse. And the other one was related to the appearance that Mr. Cox was going to make on a local television station, I believe also on the 23rd. What was the local television station? It was the television side of KJNP. What did you task Mr. Olson? Did you set restrictions for Mr. Olson in terms of what he could do operationally at that point? I did. Tell the jury about that, please. I told him that he was not going to be allowed to attend the KJB and security detail because, as we understood it, one of the requirements was that the people be armed to be prepared to use weapons. I told him that he could I told him that he could participate in the operation of or the security detail that was going to be at the courthouse if he was one of the people that went through the sterile area through security and therefore could not be armed with a weapon. And did that happen? It happened. It did occur that he communicated he was willing to be part of that escort detail. It did not happen that Mr. Cox had a court date on the 23rd, so the actual operation never occurred. You indicated before, when you have those debriefs after Mr. Olson has met with you or talked to the defendants, you sometimes provide that information or to other law enforcement agencies. Can you describe to the jury what you decided to do that, whether you did after this November the 19th, 2010 meeting? We take the information that we receive in the debrief and we evaluate it. First of all, if there is any intelligence or information that needs to be shared immediately, then we look at the information and see how it can be investigatively to support an investigation. In this particular case, we shared that information about the event that was going to be at the courthouse and about the event that was going to be held at KJNP fairly shortly after we received that information. We shared that with the Alaska State Troopers. Why? As we understood the operational plan for the KJNP detail, we believe that there could be a significant volatility as it related to law enforcement, and should law enforcement respond, the Alaska State Troopers were the designated first responders for that area. And then we would also believe that there could be potential weapons if there was a security team and an exit team that were in operation at the courthouse and they interacted with the state troopers there. Do you have an understanding of whether there were plainclothes state officers working related to this investigation? I did. I knew that there were plainclothes investigators for the state troopers through their task force who had been tasked to perform surveillance and other investigative activities in this case, and that was one of our concerns when we shared the information with the Alaska State Troopers. And when we were talking about those debriefs, you indicated Mr. Olson would provide you with information about the occurrence of these meetings. Did you provide him information, or are those debriefs really one-way streams of information? The debrief itself is a way for us to collect information that he had just gathered, any source had gathered during their tasking, and information or intelligence going back to the human source is very limited. It's limited only to the extent that it's necessary for what they're tasking them or asking them to do. Now, you indicated once you get that information, you evaluate it, determine whether you need to share it with other law enforcement agencies. Did you continue to do that throughout this investigation? We did, and specifically in November and December, we were heavily involved with disseminating information to the Alaska State Troopers because there were several in-a-row court appearances that Mr. Cox had that were some type of operational security plan in place from the militia through him, and we felt that the information was significant and how it could impact security at the courthouse, and so we continued to supply all the information over as soon as we received it from our human source. When you were debriefing Mr. Olson, did you know at the time when you were debriefing him whether the recording device recorded, whether it had recordings on it? No, ma'am. And did Mr. Olson know that? No, he did not. So when you would learn whether the recorder worked or didn't work, so when would you learn whether the recorder worked or didn't work? After I collected it back from him and after I used our software tools to retrieve recordings from the device, and then I would listen to the audio to verify that a recording had been made. So that is the method by which the when question just depends on resource-wise as soon as we could get to it. When Mr. Olson provided you information during the debriefs, did you provide him information about Mr. Fulton? Did you tell Mr. Olson that Mr. Fulton was a human source? No. He knew information about Mr. Fulton but thought he was the subject of an investigation. He did not know that he was a human source. And what about vice versa? Did Mr. Fulton know? Neither one of them knew through the arrest and searches and the conclusion of that investigation, part of the case, that either one of them was a human source. Why not? We generally don't disclose the identity of other sources to anyone, specifically to other sources, and we were also using their interactions with each other to validate the information that they were providing. And our basic operational roles regarding sources prohibit the disclosure of their identity and tactility. It wasn't appropriate for us to disclose their identity to each other. Do you know whether other law enforcement agencies did follow up on the information you provided them? Yes, ma'am, I did. Now, Mr. Olson was tasked and had some contacts with Mr. Barney in December 2010, some of which weren't recorded. Can you tell the jury why? The occasions where we would meet with one of the defendants or another individual where those conversations were not recorded were either because we had not been given a recorder, he had not been given a recorder, he didn't have one in his possession, or the person he was talking to was not someone that at the moment in the investigation we were authorized to investigate. So therefore, to record, so therefore he wasn't tasked to record them. So in the December of 2010, who within FBI protocols, who was Mr. Olson authorized to consensually record? In this case or investigation, at this point he could record Schaefer Cox or others if Schaefer Cox was there and it was a group conversation. At a later point in the investigation, was Mr. Olson tasked and allowed to consensually record conversations with Coleman Barney? Yes, ma'am. And when did that happen? Shortly after the February 12th meeting, when we were first heard about the 241 plan, and in conjunction with when Mr. Barney began to harbor Mr. Cox as a fugitive. It was sometime within the 9-day period that we were able to begin to record Mr. Barney when Mr. Cox was not present. And that's just based on FBI's restricted policies in terms of who you record or don't record. That was in compliance with our guidelines and policies. What about Mr. Vernon? When did FBI go through the internal protocols and steps so that Mr. Olson could consensually record a conversation with Mr. Vernon outside the presence of Shaver Cox? Sometime between January 1st of 2011 and February 3rd of 2011. Can you generally describe what happened in the investigation during the month of January 2011? In January, Mr. Olson was heavily involved with Mr. Cox and several of his friends who were forming an Alaska Assembly Post, a government structure. They were having a lot of meetings and discussions, selecting officers, writing policies, determining currencies to use, judicial structures, and he was involved in numerous conversations with Mr. Cox and teleconferences with other members of the Alaska Assembly Post and members of a National Assembly Post who were providing guidance to the Alaska Republic as it was stood up or they brought to life. And he was also, through that, exposed to the judicial side of the Assembly Post and took part in jury training and trial of Mr. Cox at common law and was held in Fairbanks. The Denny's trial, yes ma'am. So the first time Mr. Olson met with the defendant face-to-face as part of the investigation was at the commissioning ceremony in August 2020. That's correct. Can you describe the extent of Mr. Olson's involvement with the defendants between August 2010 and February 24th, 2011, and summarize approximately how many in-person contacts he had with the defendants during that time frame? He had limited in-person contacts with Mr. Barney and Mr. Vernon, and those mainly revolved around state court hearings or meetings that Mr. Olson attended with them. He met with Mr. Vernon and Mr. Barney several times during the week of January 10th through 16th in relation to the preparation for the trial, and he had more extensive in-person meetings with Mr. Cox at his house and in person regarding the Assembly Post. Overall, he probably met less than 5 times with Mr. Vernon and Mr. Barney during that time period, and up to 8 times with Mr. Cox, 8 to 10 times with Mr. Cox. Okay, so during that approximately 6-month period, single digits, correct. Did something change in late January, early February of 2000? Yes, ma'am. What was that? When Mr. Olson was promoted to sergeant and drawn into the command staff of the militia, he was given greater access to planning and information in personal meeting with the defendant, and his reporting in his meetings that he had with them began to really accelerate and grow exponentially in number. And so then between February 2011 and March 2011, that approximately a month to 5-week period, how often was Mr. Olson in contact with the defendants? Numerous times every week. It got to the point where it was nearly daily, and he was either meeting Mr. Barney or Mr. Cox or the Vernons, and sometimes both of them on the same day. And during these meetings, you're tasking him with regard to those meetings. Yes, ma'am. And are you following your internal protocols? We followed our policies and the guidelines throughout the investigation. Are you referring to any one specific policy? Well, in terms of when you were tasking Mr. Olson, was he following the protocols, the rules that he had agreed to abide by throughout the whole investigation and the 60 contacts I think I told you I documented? He always followed the rules. He abided by the taskings I gave him. He was where I told him to be when I told him to be there, and he did what he was told to do. Approximately how many hours did Mr. Olson consensually record conversations with the defendants? Over the course of the investigation, it was approximately 100 hours. And can you summarize how much time Mr. Olson spent on this investigation working as a human source with you? It's started to become more of a significant contribution in January. An Assembly Post was being stood up, and then in February and March, his personal involvement became significant. Like I said, it was a nearly daily, at several times every day, and it became to the extent that it affected or interrupted his ability to work. So that sort of became his full-time job during the period of time. There were days I recall specifically that he was able to work, but they were sporadic, and this became essentially a full-time job. Because you described earlier that you would meet with him before you tasked with him to go to that meeting, yes ma'am, and then he would go to the meeting and with the defendant several meetings a day, but whatever he had been tasked with, and then he would sit down and debrief you afterwards, yes ma'am, and then sometimes you did contact him again with your full follow-up questions. As I debriefed him and shared the information internally and then externally to our partners, and sometimes after we reviewed the information or reviewed the audio that he provided, we had to contact him again for an additional follow-up question meeting. How else did this affect his life? Well, it significantly impacted his personal life because he was spending so much time on the investigation, and then sometime toward the end of February when he told me that we were going to have to move him and relocate him, it significantly impacted his business that he owned and his ability to fulfill work contracts and that he had for several years out. You moved him out of his family, out of the state. We moved him. Why? Because when we assessed the situation and the level to which he had been involved and to which he had been reporting, and our view for our types of criminal activity he had been reporting on, we felt that there was a significant threat to him and his family if he remained in place. During the course of your 19 years in law enforcement, approximately how many confidential human sources have you worked with? I don't know the exact number, but it's somewhere close to 50. And based on that experience, how did Mr. Olson perform related to your taskings and your directions? Objection, bolstering, sustained. How many consensual reported conversations with the defendants occurred without Mr. Olson in this case? None that I'm aware of. So every single consensually recorded conversation that was tasked by the FBI was recorded by Mr. Olson? Yes, ma'am, that's accurate. And then he followed your directions with regard to those taskings? He did. Mr. Olson, there was testified there was some conversations that weren't recorded. Yes, there were. Can you explain to the jury, you talked a little bit before about how he was directed not to record some of those, and there were other categories to explain why certain conversations were not recorded. I will clarify that there are certain conversations that were not audio or video recorded. The conversation itself was recorded in the reporting, in the debriefing. Specifically as to audio and video, there were times he was not allowed to record based upon our internal restrictions. There were times that he did not have a device, one had not been given to him. There were 2 occasions that I'm aware of where he was given a device and followed tasking and device malfunctioned. And then there was one instance I'm aware of where he was given a properly working device and somehow it didn't operate correctly. And when he was that one instance, that was, I'm aware of, I believe it was February 2nd, 2011, and he had a meeting with Ken Thessing at the bus camper. You indicated, that it malfunctions when he's with Ken Thessing at the bus camper. Incredible. You indicated that there was some times when he didn't have a recording device. I mean, when would that happen? Are you talking about a chance encounters? What are we talking about? In late February 2011 and maybe the middle of February, he was given a device to keep full-time so that if he was contacted telephonically by any of the 3 defendants, he was tasked to start recording those phone conversations. Prior to that, he only had a recording device for specific instances where he would task him to go meet somebody. We would give him a device, task him to record, and then collect the device back from him. So prior to when he had a device full time, there were situations where he had telephonic contact or met with somebody and he did not have a recorder to physically record. We heard that testimony and about meetings or conversations between Mr. Olson and Rob Carr and Mr. Olson and Michael Anderson. Can you explain why we don't have audio recordings of those conversations? To my knowledge, he met with Rob Carr twice, one March 1st in 2010 and 2011. I'm sorry, and he wasn't authorized to record Mr. Carr based on FBI internal restrictions. He met with Mr. Carr again on March 7, 2011 in the presence of Mr. Cox. I'm going to stop here on page 51. All right, I got a little bit of time here. Let's try to get to page 60. In the presence of Mr. Cox, he had a recording device that he activated that was one of the situations where outside of his control the device malfunctioned. And can you explain how that happened? There are 2 situations that I'm aware of in this case. February 6, 2011, in a meeting between Mr. Olson and Mr. Cox at a Super Bowl party, and March 7, 2011, that was an all-day meeting between Mr. Cox, Mr. Barney part of the time, and Lonnie and Karen Vernon part of the time. On those 2 instances, the recording device malfunctioned because the recording device need 2 things in order to be able to operate correctly. They need battery power and they need a capacity to record or memory. On those 2 occasions, Mr. Olson was given a device that had been charged, but it had been used previously by somebody else, whether in this investigation or another one, and the device had not been erased before it was given to him. Our devices are such that they will not automatically overwrite anything in memory. He has to manually be cleared, and if it's not cleared, the device will come on and have a power LED or show that it's on, but it will not be recording. So would Mr. Olson have known that it wasn't working? The only thing he would have known was that they activated the switch or button as directed and had a power light, and he would have no way of knowing whether it was actually recording or not. And then when you sat down with him and had the debrief, would he have known at that point? Neither one of us would have known at that point. All I would know was that I had received a device back that he said he had used to make a recording, and all he would know is that he gave me a device and thought a recording had been made. What about the recording on February 14th at the Vernon's house? On February 14th, we decided to send Mr. Olson to the Vernon's residence with a device that recorded audio and video for a specific investigative purpose. Those devices, by the very nature that they are cameras, are much more battery or power intensive. So he was sent out there and given a general guideline of how long that device would function for. So he turned it on as directed and recorded, and then ended up staying at the residence much longer than any of us had anticipated. And at some point during the recording, the battery or power to the device failed and it shut off. Can you explain why conversations earlier in that day weren't recorded? On February 11, 2011, I recall that he met with Coleman Barney and Ken Thessing to go out for a court appearance for Schaefer Cox, and he also had a phone conversation with Mike Anderson prior to him traveling out to the Vernon's house on that day. He had not been given a recording device, so thus no recordings were made. Why wasn't he given a recording device? We spent the morning preparing the video camera and enclosure because we knew that he would be traveling out to the Vernons later in the day, so I didn't physically meet with him. I spoke to him on the phone before he went up to Mr. Cox's house and went to court, so no device was provided to him. Earlier today, there was a trooper here, and you can see there's a pocket where a big recorder goes. In this type of device we're talking about here, no ma'am. Not at a certain point. Did you make a plan to arrest the defendants? We did. And can you tell the jury about what the plan was and when you made that plan? We reached a point in the investigation where it became apparent that we would be conducting arrest of the defendants, and in conjunction with state and federal investigations, and we decided that we would arrest them in a scenario which to offer them an opportunity to purchase suppressed weapons and grenades, and they had expressed interest in acquiring, and that by doing it that way, we would also be able to control the location and time of when they were arrested, and in fact they would be arrested away from their residences. Were there going to be multiple things happening on the same day? Yes, ma'am. Okay, what else was going to happen besides the arrest? We knew going in that there would be at least 5 people that day, and we would be arrested, and the residences of those individuals, which would be 4 residences, and their vehicles would be searched, and we knew that they would require a significant amount of law enforcement resources to effect the arrest, the searches, and any interviews that needed to be done. So we constructed scenarios that would allow us to arrest Mr. Barney and Mr. Cox separately from Lonnie and Karen Vernon. Why did you make that plan to have the 2 separate arrests? We felt like we would be able to more safely effect the arrest with the resources that we had in place if we arrested them 2 at a time instead of 4 at a time. Now, in the video of the drive where Schaefer Cox and Coleman Barney are in the car with Mr. Olson, there's talk about a trailer. Do you know what they're referring to? I do. Can you tell the jury about that? They are referring to Mr. Barney's trailer. How the plans of the trailer factored into the tactical decisions that day. Part of the arrest scenario was that we would supply them suppressed weapons and grenades, and they had expressed an interest in. And then we would also make available to Mr. Cox a trucker who was going to examine personal goods that Mr. Cox had and see if he could enter into some type of agreement for that trucker to transport Mr. Cox and his family out of Alaska and smuggle them through Canada to the lower 48. Why did you come up with that? When Mr. Cox became a fugitive, we were involved through Mr. Olson in numerous conversations where he discussed how he could leave the state, whether he should leave the state, whether he should leave the country, and where he should go, as we decided as an investigative technique that we would make available an option to him so that we could control when he left. We would know when he left and where he went if he decided to leave the state. Did you keep him here? We told him that his trucker would be arriving at certain dates, but no, I don't believe we kept him here, and we didn't control his day-to-day movements at all. Were you 24/7 surveillance on Schaefer Cox at that point? No, we were not. We were having daily and near-daily meetings, but we later became aware of numerous travels and errands he was running around town and places he was going with Mr. Barney outside of our presence and outside of the presence of Mr. Olson. So you arranged a location for the sale of the weapons to occur? We did. And why did you pick a separate location like that? Why don't you just arrest them in their homes? Once we determined that the arrests were going to occur, I began to communicate with the agents in Anchorage who are charged with making tactical decisions, and based on the information I was supplying them at the case agent and the information that was contained collectively in the case file and the defendants and the allegations that were supported by the investigation, they chose tactically to construct a plan where the defendants would be arrested away from their residences in a situation where they could be quickly overwhelmed and arrested so as to attempt to avoid any type of barricaded subject or some type of standoff. Let's turn to that morning of March 10th, 2011. What happened that morning from a tactical standpoint? I don't understand your question. Earlier than the arrest. Affirmative. The first thing that happened in the morning, what happened? The first thing that was supposed to happen was that Mr. Olson was supposed to meet with the Vernons for breakfast at a place called Sourdough Sam's, and so the first place of the day was me going to meet with Mr. Olson and to follow him to that meeting. Did that happen? It didn't. When we went to start the day, put the plan in motion, we found out that this vehicle was not working because we had placed him at a motel. His being Mr. Olson's vehicle, his personal vehicle, okay, and he was staying at a motel. It was still fairly cold for Fairbanks. I think it was 25 to 30 below, and he had plugged his vehicle into a non-operative outlet, and he could not get his vehicle started. So what'd you do? We eventually got it started, and the assistance of the troopers and some equipment they brought over. It took 45 minutes to an hour to get this vehicle started, and we had, prior to that day, put recording devices and cameras in the particular vehicle. So we needed to use that vehicle, so it delayed and the start of the day by an hour, a bit or more. Now, when did Mr. Olson get the grenades and silence weapons that he was going to sell to the defendants? Where he got them was from Bill Fulton through the FBI, and the win is shortly after he got his truck started. We sent straight a different motel across town and met with Mr. Fulton. And at that point, did either of them know the other was working as a human source? No, ma'am, they did not. Was that recorded? It was not. Why not? We chose not to record it in exchange of the items, and the only reason we constructed the exchange in that fashion to Mr. Fulton to pass them over to Mr. Olson was so that we could perpetuate or keep alive Mr. Olson's belief that Mr. Fulton was a target of an investigation to provide coverage to Mr. Fulton. So it was a detail in the plan with regard to protecting one of the sources and was not something that we decided to record. What did Mr. Olson get from Mr. Fulton? He got a backpack with 4 inert military-style fragmentation grenades and 3 Pelican cases containing 22 semi-automatic pistols and an attached suppressor. And then what happened? Where did Mr. Olson go next? After he left the motel where he met Mr. Fulton, he went to a gas station across town where Lonnie and Karen Vernon were waiting for him, and then he fell in behind him and followed him to the arrest site. What did they do? What did the Vernons do? They parked their vehicles, they got into Mr. Olson's vehicle, and then as you've seen on the video, they conducted a transaction and they purchased one of the suppressed pistols and 2 of the grenades. And they were all arrested, all as in both of the Vernons were arrested at the point after the transaction. Yes, ma'am. And what happened with Mr. Olson? Was he arrested? He was arrested by law enforcement, and the 3 individuals were transported separately from the arrest site. And after the Vernons were taken away, Mr. Olson was released and tasked with further taskings for the day. And what was the next task for Mr. Olson that day? He was to make contact with Mr. Cox and Mr. Barney and essentially reset the arrest scenario and make available to them the suppressed weapons and the grenades that they had expressed an interest in. And did that happen? Yes, ma'am. Can you describe what happened at the arrest site? Prior to the arrest site, Mr. Olson met Mr. Barney and Mr. Cox in the parking lot of a bank/grocery store across town, and they left their vehicle there. They climbed in with him. They had a trip across town. They had conversation. They arrived at the arrest site, and Mr. Olson exited the vehicle. He went and got the backpack, 2 of the Pelican cases, and he gave them to the defendants to examine. And then what happened? They were examining the items. Somewhere in that time frame, Mr. Barney took and ended a phone call. And then while they were examining and discussing the items, a non-involved citizen person came up to them and began to talk to them, and the FBI SWAT team at that time decided to declare the situation compromised and effect the arrest. And so they were arrested then. What did you do next that day? After the arrest of Mr. Cox and Mr. Barney, myself and Sergeant Johnson of the Alaska State Troopers transported Mr. Cox to the Fairbanks Police Department and interviewed him. And did he agree to talk to you? He did. He arrived. He waived his rights. He did. Okay, I'm going to stop on page 61. All right, let's start with page 61 and see how far we can get. He waived his rights. He did. How long did you talk or interview Schaefer Cox after he was arrested? Approximately 7 hours. Is that normal? I have had situations where interviews lasted longer. I would say it's abnormal. It's atypical for a post-arrest interview to be that long. Why was it that long? There were several factors. One, there was a lot of things that Mr. Cox wanted to discuss. There were a number of items that I would characterize as we engaged in debate or back and forth. And then factually, there was a number of items where I felt I would characterize his responses as evasive. And I believe the volume of information and the debate back and forth and the evasiveness are what lended to being a 7-hour interview. During that period of time, though, he was always willing to talk to you. He was. And during your interview, how long did you characterize Mr. Olson? How did you characterize Mr. Olson to him? During the interview, we represented Mr. Olson as another one of his militia followers, referred to him as someone who was being booked in an investigation and who would potentially be arrested and whose residence would be searched during the day. In the time of your interview, did you have... Can you answer it? Thanks. Alright, anyway, it looks like it's a... At the time of your interview, did you have the benefit of knowing what was found in the defendant's residences and vehicles and in the trailer? There were a number of items that I anticipated would be there based on previous information, but I did not have the results at the beginning of the interview of everything that had been found. No, ma'am. What did you tell Schaefer Cox right at the beginning of the interview with him? The two things that I remember telling him at the beginning were that his family was safe and we would work very hard to make sure that they stayed safe. And after that, I told him that I heard him state on numerous occasions that he thought there was some type of federal assassin team that was looking to kill him. And I showed him nothing can be further from the truth, and that we were conducting a criminal investigation. Oh, you don't want to go kill him. You just want to capture him, put him in prison for 27 years, and torture him in a secret CIA prison. But you're going to assure him wholeheartedly that you don't want to kill him. Oh, that's just freaking insane. I hate the feds! Did I mention that? Oh, listen to this. I showed him that nothing could be farther from the truth, and we were conducting a criminal investigation. We're just here for your safety, and we're going to stick you in a CIA prison and torture you for 3.5 years. But I don't want to kill you. Incredible. The first part, why did you tell him that his family was safe? Did you tell him that there was going to be a search warrant executed? I knew that he had said before that he believed federal agents wanted to do harm to him and his family. Oh, you think his own freaking attorney wants to send him to the loony bin? You think he's got delusions, do you? How about his delusions are freaking reality? You guys are the ones that are insane. I can't even read this without getting just totally upset. He believed the federal agents wanted to do harm to him and his family. I told him that the search warrants were going to be executed and other people were going to be arrested, but that his wife would not be arrested, and that the way we were going to conduct our searches was going to be non-dynamic, and that we understood that at the Barney house there were several women and numerous children, and that we would respond accordingly. And I used that as a caveat to let him know that I was being very cautious about treating his family, and that we would be safe, and that I had interest in making sure that all of our law enforcement partners that were working with us on that day were safe as well. When you said, what does non-dynamic mean when you said that? The arrest that you saw in the video with using diversionary devices and multiple officers and swarming individuals at a fast pace would be considered a dynamic event. A non-dynamic event would be where you approach a residence or make a call into a residence and ask the people to come outside, as opposing to going up and kicking in the door. Oh, that's just wonderful. And were there additional steps that you took with regard to the family members of the search sites? Yes, ma'am, they were. Can you tell the jury what those were? We made arrests at a motel close to Mr. Barney's house and provided rooms for them because we knew that they would be displaced for long amounts of time due to the searches and the fact that we would have to render safe at all the sites, so we provided lodging facilities for their families. Have you previously reviewed clips, portions of those recordings, which were identified as CDs marked Exhibit 41 through 44? Yes, ma'am, I have. And are those clips from this post-arrest interview that you've been describing? Yeah, they are. The government offers Exhibit 41 through 44. No objection, no objection. No objection with the exception of yes, I will clarify. The government has certain clips which it identified which intends to use only against Schaefer Cox and would request a limiting instruction for the jury. And these are Exhibits 41 through 44. I can list them out for the court if you like. Yeah, you better. Miss Lamoureux, the clips that we intend to offer solely against Schaefer Cox are clips 41, 05, 6, 7, 8, 9, 10, 12, and 12, 13. With regard to Exhibit 42, the clips which are only offered against Schaefer Cox are clip 4202. And with regard to Exhibit 43, the only clips that are offered against Schaefer Cox are 4303 and 4305. There are two other clips which the government intends to offer against all three defendants, and those clips are 4301 and 4401. The court, all right, Exhibits 41 through 44 may be admitted. You heard the counsel said about the limitation for your consideration. I want to reiterate that now, that certain of these exhibits are admitted only in regard to the case against Schaefer Cox and should not be considered by you as evidence against any other defendant, and you must not consider it for any purpose other than the limited purpose of that case against Mr. Cox. And those exhibits are so limited at are 4105, 7, 8, 9, 10, 13, 14, 4303, 4202, 4305. The other exhibits are those that are those particular clips are offered against all defendants, and I would no doubt call the instruction to you further as we go along. It's kind of hard to keep all this straight, I know, but it's important that you follow my instructions insofar as you possibly can and consider the evidence for the limited purposes described and for no other purpose. Miss Lamoureux, if we could turn first to Exhibit 4105, which should be the transcript, page number 112 in the upper right-hand corner. And again, folks, this is offered against Mr. Cox only. Go ahead and play it. Are you all? Please, The court. All right. On right page, and again, let me remind you that the recording is the evidence, not the transcript. The transcript is only to aid you in understanding recording. You'll not have the transcripts with you in the jury room. They are not exhibits. The exhibits are the tape on the recording. If we could play the audio. So you asked Mr. Cox about C93. Yes, ma'am, I did. What was his response? I would characterize it as being evasive and not agreeing with the fact that he had reached an agreement to trade that for a suppressed pistol. Was his response inconsistent with what you heard in the recordings? It was inconsistent with that, with what I heard and the physical evidence and that I already received and had in my possession when we had provided that rifle to Mr. Olson. So when you say physical items, you're referring to the rifle itself? Yes, ma'am. And did you have the lower receiver at that point too, or the trigger group? I did. I received that on March 7th as well. Let's go to the next clip, play the audio. So you're having a conversation about a silencer here? Yes, ma'am. Schaefer Cox is the one that volunteers the $200 tax stamp. Affirmative. This is a follow-up to my questioning about the trading of the C93 and what was going on to get out of the transaction. And we specifically began to talk about a suppressed pistol that he was supposed to receive. And then during that, he demonstrated that he had working understanding of that fact, that the suppressors were a taxable item and that you had to purchase a tax stamp for $200 in order to legally possess one. Now, at that point, he said he indicated he'd love to have one. Did he tell you he already did have one? Not at this point. Did he later? I don't recall that he told me that he did. I confronted with him about the knowledge that I knew that he did, and then he discussed what he believed to be legal or illegal about the manufacturing suppressors on your own. He didn't tell you how quiet the one he had was. I do believe that later on in the conversation, when I mentioned to him on audio that I heard that he corroborated that his was very silent. But at this point he didn't. No, not at this point, ma'am. Let's go to the next clip. Play the audio. What's going on in this part of the conversation? We are continuing to discuss the transactions that he had been involved in leading up to the right before his arrest. And during this conversation, he demonstrates an understanding of varying degrees of firearm laws and that he understood how a private individual can legally sell weapons. And there was a threshold at which you are considered a dealer and had to acquire a federal firearms license. And then a third layer, which we have referred to as NFA, or weapons that require pre-existing paperwork. And he demonstrated that he understood that you have to send your paperwork and get a response back prior to the transaction. Let's go to the next clip. Play the audio. At the end here, he says, if it's not too expensive, what was your understanding of what he was talking about there? Both the purchase of a suppressed weapon and the paying the tax stamp to make it a legal NFA item. Was that consistent with the facts of the investigation? It was not, because I knew that he had previously arranged for payment of a pistol as he expected to be delivered on March 10th by supplying the rifle to Mr. Olson. Now there's also a reference when he says, if I want a pistol with a suppressor, which is just because it's cool and sexy, and he talks about like a toy for toy purposes. What was your understanding of what he was talking about there? I believe that he has mischaracterizing his intent and that he wanted a suppressed pistol simply for its novelty or to have something that was essentially just a toy or a fun item to have, and didn't believe that it was consistent with the investigation. Have you already heard he didn't tell you about the killing power of a .22 silenced pistol? He didn't, no ma'am. He didn't tell me anything about the conversation that he had on the way to the arrest site regarding a .22 as opposed to a 40 or 9mm that he had ordered, and why that was or was not acceptable. So how much time had elapsed between him talking about his .22 silenced pistol in the car ride to the arrest site and doing the arrest, and when you were asking him these questions during this interview? At this point, it probably 3.5 or 4 hours after he had that conversation. But he didn't mention that to you. No, he did not. Let's go to 41-10. I think we're going to have to leave that for the morning counsel. Yes, Your Honor. Ladies and gentlemen, again, let me remind you of my instructions to you about recesses. Don't discuss the case with each other or anyone else. Don't read or view or listen to any news accounts of it. Don't let anyone talk to you about it. Don't do any independent research, computer or otherwise, on any of the matters that you heard discussed in court, because we don't want you to go learn the truth. You got to just get your information from our controlled courtroom. Keep your minds open at all times. You have not heard everything yet by a long shot, and we are going to start at 8 in the morning. Can you all get there half an hour earlier tomorrow, because we are going to stop at 1. So be here at 8 a.m. instead of 8:30 tomorrow, and we'll continue with Mr. Agent Sutherland testimony at that time. Okay, you may be excused. Leave your materials. The court. Let's talk about your future here for a second. Is this your last witness? Yes, Your Honor. And we have a ways to go with him across, and I assume that there will be some motions when the government rests, and I don't want to assume that, I guess, but it seems that to always happen, and I'm kind of thinking about how much time that's going to take. It would be very helpful if any motions you wish to make are divided or bifurcated or whatever into individual counts and individual defendants, because if you make a blanket motion in light of that many notes, it may not make a whole lot of sense to me. And so if we can divide it up into individual counts and individual defendants, insofar as that makes sense, and on the rule and those things as we go along, it will be much easier for the judge, and it will be much easier, I expect, for the government to, well, respond by pointing out to specific evidence. If it's a challenge to the sufficiency under the individual count or individual defendant, it will be much easier to discuss the whole thing with one item at a time instead of trying to lump all this together. I expect it will go a lot faster too. So let me ask you to plan that. I don't know how much time to take. I guess we ought to finish with the government's case and put the jury on ice until we get motions resolved, and then start with the defense witnesses. Traverso tomorrow. The court, okay, start with the defense witnesses tomorrow? I would hope so. Okay. I can't imagine spending the whole day on motions, but I take the motion seriously, not just pro forma. So we'll deal with it in order, and we'll just keep the jury waiting while we do that in hopes that we can get the rest of the day until 1 with further notice. Okay, so see you in the morning. All rise. This matter is in recess until 8. This dishonorable court is adjourned to subject to call. And that's the end of the Sutherland testimony for this particular day. My goodness.